Logical evening, everyone. So here we go. Vidhigya India Open Mock, the analysis of legal reasoning section. I'm sure that today you had great learnings. When I talk about today's test, it was really competitive. And talking about the section legal reasoning per se, before I start, last 2 weeks to go. Have the hustle mode on. It's required. Then this is where we want you to be. This is it. You know, the yellow one. This. Don't forget this, huh? This quote. Give 30 seconds to it. It is that ways. All right. Worrying is like a rocking chair. It gives you something to do, but doesn't take you anywhere. That should not happen. बस लगे रहो. Keep pushing yourself. Slog harder. बिल्कुल अच्छा नहीं गया mock. Trust me, we have prepared you to the level that CLAT cannot surprise you. And let me be accountable saying so. All right. चलिए. Difficulty level moderate to tough के बीच में. Now, to begin the analysis, let me tell you today we had 8 passages. And in these 8 passages, we had a great variety of questions, right? First, we had draft rules on live streaming. It was contemporary legal development. Then we had a question on criminal trespass from criminal law. Then we had GNCT Amendment Act. On that, a very good question frame. Then Copyrights Act. We had something to test in this as well, which was easy to moderate. Power of pardon, clemency ki baat, strict liability, misrepresentation, and death penalty. So constitution, contract, tort, static legal GK, and contemporary legal development, a mix of almost everything. Anshika says that today's mock was very difficult. I lost all my confidence. No, not to lose confidence. We are ensuring that every kind of test you should be able to take. So there should be nothing on the D-Day that can surprise you. Needless to think so. What is there in this test, be it any section whatsoever, there is a lot of learnings. There are a lot of learnings and I wish you take that. है ना? Chalo. Well taken, Deepthi. All the best. At that time, I was writing the test, so maybe you gauged it right. Khair, going ahead. आज के मॉक में लीगल में I have put benchmark a bit higher. तो मेरे हिसाब से stellar performance is 33.5 out of 40. Good performance is a score of 30 plus. Decent performance is 25.5. Average performance is 23.5 के ऊपर. 20 से नीचे नंबर आए तो मेहनत करनी पड़ेगी. Need to improve. That's how you know the sectional score analysis should be like. Having that point settled, offset method पता है, so would not explain much. ये बात 100 times I've told you. Needless to say again. Focused mind. Sequencing. Ask me anything. A lot of students have started posting queries. From tomorrow at 9, you'll get a lot of answers to your queries. It would be a wonderful time that we'll spend together. Anyways, let's start with the passage. The passage, what it had. This passage may just for the heck of it, you know, some legal knowledge was also shared. All right. Not legal GK के कुछ questions बन जाएंगे passage अच्छे से पढ़ा दो. Anyways, now these passages are the passages which you know we have written. So when we talk about these passages, this passage particularly is about live streaming. Then the live streaming started with a judgment. Then there are certain drafts rule. The draft model rules for live streaming we call them. In this, criteria is given when live streaming should be done, could be done, etc. etc. And you need to understand the meaning of this word, justiciable. बोलते हैं ना, directive principles of state policy are non-justiciable rights. You need to know the meaning of word justiciable. All right, going ahead. What then again, the draft rules mention about how objections can be done, records of the proceedings. So Soumya, towards the end we'll talk about it. मैं last में बता दूंगा what should have been the sequence, intersectional sequencing की बात करें, I'll tell you. But at this given point in time, let's see. When we talk about the passage of legal reasoning about live streaming, this was in particular to say that after 2018 judgment, live streaming has been allowed. There have been some draft rules, draft model rules for live streaming and recording of court proceedings. So these rules have been done, and this is available at this website. It was retrieved from there, and on those areas the questions were being made by us. So when I talk about this particular passage, let's I've already shown that the broader idea should have been clear. Since you have already solved these questions, so I'm not going into explanation of passage, straight away coming to the questions. है ना? Good, Harsh, you are right. Vidhi filed a criminal case in High Court against her husband, alleging that he used to beat her during first month of their marriage. She further alleged that kept coercing her for dowry. Can such case be live telecasted according to the provisions? Now, we have already seen that matrimonial disputes, etc., etc., it is clarified that such matters cannot be live telecasted. So it's no brainer. Priyashi, Kaushiki, Parul, Soumya, Mahima, Samta, great going guns. Answer is B, Bombay. Correct. It cannot be done because it is involving gender-based violence and matrimonial dispute, वगैरह वगैरह, that cannot be taken online. With this point settled, let's go to the next question. Now this case is about two religious communities. हमें ये देखना था, हमारे पैसेज में बहुत क्लैरिटी से लिखा था कि कौन से मैटर्स ऐसे हैं जिनकी लाइव स्ट्रीमिंग नहीं होनी चाहिए. Talking about question number 2, so the issue is, question number 2 is interesting. Let's see. The main question involved is the place of both communities claim on. There's a large number of. It is decided by the court to not to live telecast. Filed an objection. Now, in this passage, the idea is very clear. That passage clarifies, I repeat, the passage clarifies if the court has decided to live telecast, you can have an objection not to live telecast. I repeat, passage में ये clearly given है कि अगर कोर्ट ने किसी मैटर को लाइव टेलीकास्ट करना अलाउ किया है तो आप ऑब्जेक्ट कर सकते हैं कि इसे लाइव टेलीकास्ट मत करो. पर यहां कोर्ट ने उल्टा किया था. Court decided not to live telecast. Then the question is, can an objection be sustained? Answer is no, which is why Vidhan cannot file objection against the decision of the court not to live telecast because it is not permitted by the rules. B, Bombay is the right answer. Sakshi missing the bus, others are right. चलिए. Reasoning में कोई problem हो तो keep asking me. If reasoning is clear, I would just try to tell you what were the areas which you should have seen in the question और फिर क्या answer होना चाहिए उसका. Now the third question that we have, the rules are very clear कि live telecast कर सकते हैं या नहीं कर सकते हैं अलग अलग प्लेटफॉर्म पे. In that it is already given. अब question ये है कि Allahabad High Court has decided a case about fundamental right of speech and expression. Vidhan, a lawyer who argued the case, have telecasted live stream of the proceeding on NewsTube, a video platform. The question that we have कि ऐसा क्या होगा इस केस में. Now these are the brilliant questions. These are the kind of questions that CLAT should be asking, and let me say this, having my neck out, CLAT should be asking such kind of questions. Which of the following, if true, will strengthen the case for Vidhan if his actions are challenged in the court? अब उसमें रूल्स में क्लियरली गिवन है कि अगर कोर्ट से कंसेंट ले ले तो आप पब्लिश कर सकते हैं, वरना नहीं. सो इन दिस केस द ओनली आर्ग्यूमेंट दैट स्टैंड्स गुड इज had he taken the consent of court before live telecasting the proceedings on NewsTube. Answer is C, Calcutta. People marking C, good going. आपके पास आजकल टाइम बहुत कम है इसलिए आई एम गोइंग अ बिट फास्टर. किसी को डाउट हो क्वेश्चन में तो आई एम आंसरिंग एज वेल. ऑलराइट, क्वेश्चन नंबर 4, relying upon the information provided in the said rules, which of the statement author is most likely to agree with? है ना. Now Question number 4, when we talk about proceedings and agree लिखा है. Proceeding in all cases should be live telecasted? नहीं. As in India, it takes long time to file an appeal? नहीं. Technicalities involved in live proceedings makes it time consuming? ये तो antithesis है ही नहीं. अब वैसे ही मुझे मालूम है डी आंसर हो रहा है, लेकिन द नेचुरल प्रिंसिपल ऑफ रीजन डिसीजन डज नॉट कवर द कंटेम्पलेशन एंड डिस्कशन ऑफ जजेस ड्यूरिंग हियरिंग, इसीलिए इसकी लाइव टेलीकास्ट नहीं होती. डी दिल्ली इज द आंसर. पीपल मार्किंग डी दिल्ली. गुड गोइंग गन्स. नेक्स्ट, which of the following can be inferred from the passage? Now this is interesting. Which of the following can be inferred from the passage? 1, when you talk about this, Article 21 is a vast provision and subsumed a number of rights in its ambit. ठीक है, seemingly right. When you talk about question 5, artificial intelligence based on SUPACE launched by Chief Justice of India aimed at assisting judges with legal research has proved complete failure. Not at all. Violence against children, violence against a particular genders are the ones which are most covered by social media. It cannot be inferred. Extraneous, because peculiar problems technology cannot be used. Eliminations ही खत्म हो गए. A is the only possible answer. A, Agra is the answer. Great going. Good. Now let's come to passage 2. Now passage 2 was talking about an offense of criminal trespass. Now they have defined that what is the meaning of criminal trespass and says that it has 2 limbs. पहला तो कोई किसी की प्रॉपर्टी में एंटर करे विद क्रिमिनल इंटेंट, और दूसरा वो प्रॉपर्टी में एंटर तो लॉफुली करे लेकिन बाद में उसी प्रॉपर्टी पे खड़ा रहे विद क्रिमिनल इंटेंट. मैं आपके घर गया तो मिलने था, फिर मैं आपको अनॉय कर रहा हूं, आपने बाहर जाने के लिए बोला पर मैं फिर भी वहीं खड़ा रहा विद एन इंटेंट टू कॉज अनॉयंस. तो इस तरीके से दे हैव सेड दैट व्हेन इट इज क्रिमिनल ट्रेसपास इट हैज गॉट 2 लिम्स. एक, गलत तरीके से अंदर आना, दूसरा आना सही तरीके से पर गलत तरीके से बाहर रहना. राइट. नाउ दे हैव एक्सप्लेन्ड यहां पे ये विद एन इंटेंट टू देयरबाय इंटिमिडेट, असॉल्ट और अनॉय सच अदर पर्सन. फिर वहां हुएवर एंटर्स में बताया है कि व्हाट इज द मीनिंग ऑफ वर्ड एंट्री. फिर प्रॉपर्टी में बताया दैट इट इंक्लूड्स मूवेबल एंड इमूवेबल बोथ, सो कार इज ऑल्सो अ प्रॉपर्टी फॉर दैट पर्पज. पोजेशन ऑफ अनदर में पोजेशन और ओनरशिप का डिफरेंस बताया है. सो दिस वाज द पैसेज ऑल अबाउट. एन इंटेंशन अगेन वाज क्लैरिफाइड. Intention, if it is not to insult or harm, then it is not criminal trespass, and this case was being let down. They entered into bank only for mounting pressure and they were not there with any criminal intent, and hence it was held that it does not amount to criminal trespass. This was a area which was being asked in this passage. The passage was simple. You have read it enough, so I'm just demarcating the areas which you should have paid attention at, and we are going faster. Now, question number 6. X and Y were neighbors with extremely hostile relations. On 5th June, X decided to annoy Y in pursuance of that plan, started playing loud music. Now, loud music, when we talk about loud music, doesn't mean enter. So therefore, there is no actual entry. तो trespass हुआ नहीं. People marking 6. Harsh, Aditi, Priyashi, Soumya, Mahima, Vaishali, Kaushiki, Parul, Samta, Priyashi. They all are right. Good going. Let's go ahead. In the definite, now this is another variety of question. We try to ensure that all the different varieties of questions that can ever be asked are brought to you in the mock itself. If in the definition of section 441 as provided in the passage, suppose the original text first line is replaced by, मतलब 441 की जो definition लिखी हुई है उसे पहली line को अगर replace कर दें, कैसे? Whoever enters, और word क्या यूज हुआ यहाँ, or causes to be entered. Then what would be the impact on the situation? Last situation. और X ने यहाँ अपने बेटे को भेजा, तो क्वेश्चन है, और बेटे ने यहाँ के वहां क्रैकर बस्ट कर दिया. क्वेश्चन ये है, इन दिस केस he is causing to enter his son to burst cracker. So people, those who are marking D, they are typically wrong. Answer is C, Calcutta. Malicious intention से ज़्यादा important है. By the virtue of sending his son inside the house. Why? Because in this definition, causes to enter was being added. 7 is C, Calcutta. Going question number 8. Vidhan was a landlord who let his house on rent to Vidhi. June 2022, failed to make payment. Vidhan picked up his gun and entered house. Now we need to understand criminal trespass ka funda. Criminal trespass is not against owner, it is against possessor. So in this case, Vidhi was possessor. तो विधि के घर पे अगर कोई गन लेके एंटर हो जाए, भले ही वो उस मकान का मालिक क्यों ना हो, we get to be clear that it is amounting to criminal trespass. Answer is A, Agra. Everybody marking Agra is good. Let's go to question number 9. VBI Bank were holding a strike in head branch. ये जो case law था, the case law which was provided, the case law in passage, उसी का भाई है ये question, right? At one time they entered into the cabin of the general manager of the bank, peacefully explained their demands to him. This is important. General manager, so that he teach him a good lesson in a brutal way after everyone has left. सारे लोग peacefully आए थे, ये जो X था ये वहीं छुपा रह गया. He did not, he entered lawfully, but he had hidden in that cabin with a criminal intent. Therefore, when we talk about question number 9, D, Delhi is the only possible answer. People marking Delhi, good going guns. Which of the following best summarizes the offense of criminal trespass as mentioned in the passage? Now, we at Vidhigya are ensuring that legal reasoning is taken next levels. You know, the kind of paper it should be brain churning, and you should have great learnings, which is why when we talk about question number 10, best summarizes the offense of criminal trespass, and simpliciter, if we see, criminal trespass is aimed at protecting a person from any unlawful, no, ownership तो बिल्कुल नहीं, it's possession, गलत हो गया. Aimed at protecting a person from any act that intimidates, no, not any act. B is wrong. People marking B in question number 10 are absolutely wrong. Tanu, Laksh, Aditi, you are wrong. I'll explain. Not B, because from any act which intimidates me, an act where a person enters, entry is important. It is aimed at protecting person from any unlawful act against the possession of property held by him. Now this is where your answer is. C is the answer. Entry is required. Every act that intimidates, insult or annoys such person, if not entering the property, cannot be the crux of criminal trespass. Trespass requires transgression and interference with the possession of property. C, Calcutta is the answer. I hope you got it right. Now see, let's come to passage 3. Now passage 1 and passage 2 basically might be seeming के general knowledge में कैसे बना दिया आपने legal का question, so it was interesting for us. It was indeed interesting to make some questions in this area. Now, how to look at this? To look at this, यहीं पे ऑब्जेक्ट है, ऑफसेट का ओवरऑल पैसेज का मतलब देख लो. ये जो नया अमेंडमेंट है, इट्स टॉकिंग अबाउट एन अमेंडमेंट टू एन एग्जिस्टिंग लॉ, एंड दिस अमेंडमेंट इज गिविंग प्राइमेसी टू LG over elected government. That is the idea. Next, provisions 1, 2, 3, 4, 5. These are the sections amended. These are the things written. This is important, this is important, this is important. I am sure you would have read it well. Now, background is here this act was made, the purpose was defined, and 69th amendment is discussed, where two sections were, and this section and the provision. These are important. फिर सुप्रीम कोर्ट का एक जजमेंट इन 2018. अब ये पूरी कहानी ये है कि बैकग्राउंड क्या था दिल्ली का, 69th अमेंडमेंट क्या बना, कैसे 2018 के जजमेंट में क्लैरिफाई किया, इट्स द डेमोक्रेटिक गवर्नमेंट नॉट द एलजी. एंड 2021 का एक अमेंडमेंट उस लॉ में गिव्स प्राइमेसी टू द एलजी ओवर द इलेक्टेड गवर्नमेंट. So that was the crux of this amendment bill, and this is again, written by us, a decent passage. So let's get into the questions. The questions are: in the light of the passage, which one of the following is a valid law? Now, question number 11. An act passed in 2020 by Legislative Assembly of Delhi or matter of public order. Public order was not in that list, so this goes wrong. This goes wrong. Granting, wrong. In the matter of concurrent list, after granting opportunity. यहां विदाउट था ना, इसलिए यहां विद है, आफ्टर है. मैटर ऑफ पुलिस, यहां पे पब्लिक ऑर्डर के कारण गलत, यहां पुलिस के कारण गलत, या विदाउट के कारण गलत. आंसर इज सी, कैलकाटा. Now this question would be right only to the student those who have understood the passage, and this should be the rule that we apply while solving question. 11th is C, Calcutta. Going 12th, X is the Lieutenant Governor of NCT of Delhi. Z is the Chief Minister. The Council of Ministers proposed to implement the decision on tax laws which would raise the tax and sale of liquor. Which of the following will make the law valid? If the law has been made by the government at the discretion of, no, ऐसा कहीं नहीं लिखा है, not at the discretion. If the law has been made by LG, had been granted an opportunity to give, yes, that was required, that he should be granted an opportunity to give his opinion before any decision is taken, making sense. But I'll still read two more. If the law had been made in concurrence with 10%, extraneous, it is extraneous, it is not provided for. If the law has been made by the president, had granted opportunity of being heard before any decision was taken, council. President. Answer without an iota of doubt is B, Bombay. Parul marking C, Anurag marking C. That has been horrendous. Aviral should not retract messages. Delete नहीं करना चाहिए, जो लिखा वो लिखा, क्या दिक्कत है? Coming to question number 13. In fact of the above questions, suppose, वो यही वाले questions, last question की continuation वाले. In the facts of the above questions, suppose X, the LG, has proposed to implement tax law on liquor. Z, the CM, challenges the said tax law. Which of the following argument can be taken by X, that is LG, to justify his action? Lieutenant Governor के favor में कौन सा इसमें argument रहेगा? These are good questions. What goes in favor of Lieutenant Governor? Provided discretionary power to refer matters, extraneous, ऐसा कहीं नहीं लिखा. Provide discretionary power with regards to central government is empowered? No. We are going with question number 13. D, Delhi is the right answer. Now, which of the following is correct as per the passage? Now, this is about the factual matrix. So, again, 1991 to increase the power? No. When you talk about question number 14, this is not correct. To increase लिखा है ना? Parity between Delhi and other states? Not at all. Not at all. Now, please understand this question number 14. I'm just marking which things have, will was to be seen while marking questions. Constitutional primacy of and cooperative federalism. Amendment Act. It is against primacy of this and this. So ये इसके against है. ये amendment is against representative government and cooperative federalism. So again, this is wrong. Absolutely right. D, Delhi is the answer. People marking Delhi, kudos to you. Let's get into question number 15. The last question of this passage. Which of the following can be inferred from the passage? In question number 15, the power of president to suspend the operation of any provision is limited to the provision under 239 AA. Now we'll talk about this. This cannot be inferred. This is wrong. The spirit of the said amendment, is not in consonance with Supreme Court judgment. Answer is yes. The Legislative Assembly and a Council of Ministers for NCT has absolute power to make laws concerning all matters. No. New sections तो नहीं हुए. Old में amendment हुआ है. The only possible answer is question number C, B, Bombay. This is the right answer. Wrong. This is right. 15B, people marking B, they're right. Rest. Let's get to the next question. The next question is about the copyright law. The first part of the passage, the first paragraph, explains about the meaning of term work, what all is included. Then they say what is literary work, dramatic work, musical work. This is cinematograph film and sound recording. Now, this is all what is encompassed within the said copyright law. Now, these are the new things which have been introduced. This part. This is telling that our law is in walking in pace with the need of the time. The registration is not mandatory. It's an important line to pick. Then enforcement का process दिया हुआ है और process में दो बातें हैं, civil as well as criminal. Civil remedies in form of injunctions and a cognizable offense. And the penalties. I'm just telling you the structure of passage. You have already read it, but I'm trying to draw your attention towards what you should not have missed. Then they're saying the second time a person commits offense, you need to ensure that passage jab padho, to you need to understand when you start till the end, you are able to understand and carry the crux of the passage, and you have a mental map clear. That I always say, what is given in the passage, you're crystal clear about it. So then they're saying register an FIR, seize the infringing material without intervention of court. Now the next question is licensing and assignment of copyright. Licensing and assignment of copyright. When you talk about licensing and assignment of copyright, then the question is how can it be transferred? Assignment is transferring, license is permitting somebody to use. And then the duration of copyright 60 years plus life of author and 60 years. So this is all what this passage was. Now based on this passage there are questions, so let's go into the questions. Which of the following can claim copyright protection under Copyright Act? Now we need to read the passage well. Is a wildlife photographer and took a rare exotic bird. करेक्ट, ये तो हो सकता है, हमने पढ़ा था पहले पैसेज में दिया हुआ है. फोटोज आर सब्जेक्ट मैटर ऑफ प्रोटेक्शन अंडर कॉपीराइट लॉ. He produced a film, cinematograph film is covered. Z invented a camera. Inventions are not covered. It is subject matter of invention. क्या होती है? इसका पेटेंट होता है. So answer is D, Delhi. Going next. Y claimed copyright on his film ABC. published in 1914. Now this is the question that I'm looking forward to. 17 का आंसर बताइए फटाफट. Question number 17, I'm looking forward for your answer. Now they say it was made in this time and it was this year. So what would be the answer to question number 17? Quick go. B, C, B, A, B, A, C. All three options you have got by now. Only D is missing. B, C, and D. This is what we are getting. Let's understand. Movie was made and published in December 1914, and in January 1974 another movie was made which was on the same theme, which is a copy of this film. Which of the following will strengthen the argument of Z against the claim of infringement by Y? Y की मूवी थी 1914 दिसंबर में और 1974 जनवरी में इस पे एक मूवी बनाई Z ने. क्वेश्चन है आपको वो आर्ग्यूमेंट चुनना है जो Z यूज करेगा against the claim of copyright against Y. So when you go with question number 17, you get to understand one good thing. That पहला वाला अगर आर्ग्यूमेंट देखें, the film made by Z is substantially different from the film. It would be a very good argument. Let's hold our breath. हम लोग देखते हैं. It's a good argument. क्वेश्चन ये है जो नई मूवी जिसने बनाई है 1974 में उसके अगेंस्ट में क्लेम हो रहा है कि उसने कॉपीराइट वायलेट किया है. अब उसको अपने आप को डिफेंड करना है कि मैंने कॉपीराइट वायलेट नहीं किया है, तो उसके फेवर में कौन सा आर्ग्यूमेंट है जो जाता है? ये वाला आर्ग्यूमेंट जा रहा है. 17 क्वेश्चन में ए ऑप्शन. आगे देखते हैं. द फिल्म मेड बाय जेड वाज पब्लिश्ड इन 1974 एंड देयरफॉर वाज आउट ऑफ कॉपीराइट प्रोटेक्शन. आई वाज नोइंग मेजॉरिटी. This is A, this is B, this is C, this is D. I'll tell you B is wrong, and I was knowing that you would calculate December 1914 and 1974. I'll tell you. It is said 60 years from the proceeding next year. मतलब 1915 से 60 years. और दूसरी चीज दिसंबर 1914 के 60 years कंप्लीट होंगे दिसंबर 1974 में. या जनवरी लिखा है, तो स्टिल द पीरियड ऑफ 60 years नहीं हुआ और वही बोलते 60 years from the preceding year. So it becomes interesting. It was a twister. It was an intended twister. This is wrong. The film made by Y was not registered. हमने पढ़ा है registration of copyright is not a condition precedent, not a requirement. Again wrong. The term work did not include cinematograph films. Nonsense. It includes. The only argument that goes in favor of him is कि 60 years का ही टाइम है. वो जो मूवी मैंने बनाई है और वो जो मूवी पहले थी वो बहुत अलग थीम्स हैं, बहुत पूरी कहानी अलग है. I have not copied. That's the argument that can go in favor of him. People, majority, marking, Bombay goes wrong. पढ़ा आपने? ये देखिए ये. If you'll tell, I'll highlight 1 million times. It was intended to be tricky. Otherwise, what's the point writing questions? चलो, ट्रिकी था तो लेस ट्रिकी देख लो, सिंपल वाला देख लो, क्या फर्क पड़ना है. In the last mentioned question, assume that Mr. Z is convicted for infringing the copyright of Y. What would be correct? पैसेज के हिसाब से क्या करेक्ट होगा? He can be stopped circulation. बिल्कुल रोका जा सकता है. He can be told to pay the fine. हाँ, इनको बोला जा सकता है. Then Z can be asked to transfer to Y all the profits which he has made after screening the infringing work. Yes, the answer is D. Delhi. All right. Wonderful. पढ़ने पढ़ाने के काम में भी cockroaches are everywhere at times. All right. Question 19. While investigating a case of copyright infringement of a book, the police entered the premises of Mr. A, the author, and made search and seized the copies of infringing material. एक के घर में घुस के पुलिस वालों ने सारा सामान जब्त वक्त कर लिया. क्वेश्चन है कि जिसके घर में घुसे उसके फेवर में कौन सा आर्ग्यूमेंट जाएगा? What would be the argument that goes in the favor of the person in whose house they have entered? Question number 19. Interesting questions. Everybody is right. D-Daily. Interestingly बताओ, पैसेज में मजा आया, ब्रेन चर्नर था. I hope you got a lot of things to think. Yes or no? If you liked the last question, like this, I would be happy to see your likes. Indeed, last one was interesting. Last question deserved it, actually. You were tricked, and CLAT has asked such questions. CLAT has asked such questions. So CLAT ने questions पूछे हैं ना? This is this simple. Let's go to question number 20. Chalo. Let's go to question number 20. Relying upon the information provided in the passage, which of the following statements is author most likely to agree with? Author agree किस बात से करने वाला है, वो question देखना है. Okay. Wonderful. मैंने गलत कर दिया, तभी तो था ये क्वेश्चन, तभी था. The number of people attending the sessions and number of people liking that questions are not similar. So if you liked, then only you click like, otherwise not. हाँ, तो क्वेश्चन अच्छा लगा तो लाइक करना, वरना मत करना. ठीक है, चलो आगे चलते हैं. क्वेश्चन नंबर 20 देखते हैं. इनमें से कौन सी ऐसी बात है which author would like is likely to agree? Information technology industry has progressed far. No. Performers right has not been. Not के कारण गलत. Work protected under copyright even if they're not being registered. Exactly. Touche. Licensing can be done only for past work. No. The answer is C. Calcutta. All well. Let's go into passage 5. The passage 5 talks about the power of pardon of the president, the clemency power. All right. There were certain things which were tweaked in the passage so that your prior knowledge doesn't help you enough to solve questions. At times I have seen students, passage तो पहले से पता है ना, थोड़ा सा देखा हुआ है ना, let's go to questions. Wrong way. The scope, the ambit of passage. I repeat, the scope, the ambit of passage determines your answer. Please be very clear that you don't apply what we call it Vidhigya PSG, Purva Sanchit Gyan, prior acquired knowledge. You have to answer which question, you have to answer the question in the light of the information provided in the passage, should not go beyond. चलो बढ़िया अविरल, मजे करो ना, सीखने के लिए बहुत था आज. Right? The power of pardon is founded on consideration of public good and is to be exercised as a ground of public welfare, वगैरह वगैरह. Now, this is where it is showing that why do we require? Here they are saying, sharing the objective of power of pardon. Then they're saying that in India, president and governor can do it, and these could be the modus. Now, in this passage, Article 72 की कुछ बातें लिखी हैं और उसको थोड़ा सा tweak कर दिया है. So some tweakings are there. Then what is given? What is the limitation of law? These are the passages where things are even defined for you if you can understand well. All right. Then procedure. Finally, reconsideration. If president sends his advice, what is the procedure? Or procedure में लिखा है that should be sent to the Council of Ministers, and then the president is bound to act. He can send once for the reconsideration. The next time it comes, he is bound by that, so on and so forth. So that's how it is. Now let's go to the questions. Question number 21. A person is a thug. He's being sentenced for 10 years, right? and he's asking for pardon. What will be the outcome of the petition considering the cabinet ministry has agreed to whatever the decision president takes? So on question number 21, what is your answer? Please be a bit quicker so that we can see your answers. इस पे कैबिनेट ने मंजूरी दे दी. The cabinet has concurred that whatever president say, we are okay with it. So question number 21. Question number 21 is a no-brainer. Everybody marking A, one child marking C, other marking B. So it's going this way. A, B, B and C. Great going. A is the majority. Most of the students are marking A. And mind well, majoritarian view is not always correct. It might be correct, but not always correct. The question number 21, the answer to this question number 21 is going to be C, Calcutta, and I'll explain why as well. And if you like this and if it is a twister and where you missed, then do like it. If you liked it, then like it and tell me. और या बताना, इसको समझना, इसको बिना समझे आगे मत जाना. आपने पढ़ा under 72 president can grant pardon for offenses. Okay, let's see. President can confirm cabinet. ये भी हमने पढ़ा था. President cannot grant pardon. इसकी reasoning समझ में नहीं आई. President can only interfere with reprieve. This is extraneous. Now, I would want to draw your attention towards this point, and this is where you did not read well. This power is of any president where the sentence is death. This power of president is available, though it is not the law, but the passage was tweaked. The passage was revised to include this provision. Right? And here when you see, then the person is sentenced and I marked as well for 10 years. So the answer is that president cannot grant pardon. अब वो कैबिनेट हाँ भी बोल दे और वो देना भी चाहे तो भी नहीं दे सकते. सेंटेंस शुड बी डेथ. दीपिका मोहनानी और हर्ष गौर, they are razor sharp with their reasoning. Good going with Kaushiki in the club as well. आगे चलते हैं. 22 देखते हैं. A was found guilty of murder of both friends B and C by Supreme Court. यहाँ डेथ पेनल्टी है. The petition was refused twice by them. President still granted them the commutation. उसमें लिखा था प्रेसिडेंट एक बार भेज सकते कंसिडरेशन के लिए. अगर दो बार रिजेक्ट हो गई तो आप प्रेसिडेंट नहीं भेज सकते. That is final. So the answer to the question number 22, I repeat, the answer to this, it was tricky one, तो अगले भी मजा आएगा. 22 का आंसर is प्रेसिडेंट को दो बार हो चुका है तो will president's decision be allowed? Answer is no. For question number 22, it's no, and answer C, Calcutta. Sanskar Patidar, Aviral, Deepika, Yogendra, Aditi, Kaushiki, Harsh, Parul, Alok, Mihuka, Samta, Tanu, Rachit. Everyone is right barring Rachit. It's C, Calcutta. दो बार का लिखा हुआ है वहां पे रिकंसिडरेशन की बात जो है रिकंसिडरेशन. Let's go ahead. Under which of the following situation can president use his power granted to him under Article 74? A is found guilty of murder. A is found given life imprisonment. यहाँ होगा यहाँ नहीं होगा. Answer is going to be only 123 का answer happens to be C, क्योंकि यहाँ sentence क्या होगा? Life imprisonment. Those who have missed the logic the last time, वो एक logic अगर miss हो गया कि this is available only against in the cases where it is death penalty, so you will miss the bus. All right, 23 is done. Let's go to question number 24. Aviral 23 का B कैसे बेटा? 20 संस्कार पाटीदार absolutely wrong. चलो. K was a serial rapist. He was sentenced to death. तो ठीक है, यहां हो सकता है. Upheld by Supreme Court. He filed a mercy petition. The petition was denied by president. K filed a petition for reconsideration. The president can president reconsider it after declining once under Article 74(1). Now the question is 24. Article 74(1) provides that president can send to cabinet for reconsideration. So if the person is filing again for reconsideration, it is absolutely wrong reasoning. Question number 24. People are marking B. No, I mean very less students understood that this is the reasoning. It has no application in the factual matrix. Again, most of you taken by surprise. So जितने लोगों का गलत हो गया, like this. You missed it. You were tricked. Let us see this question number 24. You were tricked. 74 clause 1 is about कि president cabinet के पास एक और बार reconsideration के लिए भेज सकते हैं. People marking B not happening. Why? Read 74.1. 74 clause 1 की हिसाब से बात हो रही है. So people marking any other answer, they were wrong. Let's go to question number 25. Which of the following can be inferred from the above passage? Pardoning power of president can be applicable in relation to penalty for a criminal offense. सही है. Pardoning power of president does not apply. गलत है. President has complete authority to pardon the power without any challenge. Complete authority नहीं है. कैबिनेट से पूछना पड़ता है. ये नहीं होगा. इसका आंसर हो जाएगा ए आगरा. Deepika Mohanani, you missed the bus. Can be applicable in relation to penalty for a criminal offense. Yes. Criminal offense ही तो है death penalty. Can भी लिखा है. A Agra is the answer. Passage number 6. The popular case of Ryland versus Fletcher. Ryland versus Fletcher, the rule of strict liability is something that every law aspirant is clear about. So anyone taking exam on 2022, I think this topic is sine qua non for your preparations. I think it is the first condition that you should know while studying torts. So there's no point that I explain you what Ryland versus Fletcher is. The first paragraph of this passage talks about the factual matrix of Ryland versus Fletcher. The second paragraph talks about the principle laid down in this case that if you have dangerous things stored on your premises, which is a tendency to escape, that escapes causes loss. With non-natural use of land, tantamounts to strict liability. In that case, the person who stored such dangerous thing on his premises is liable to compensate. So that's how it is. Then they suggested what are the essentials of strict liability. Bola dangerous things stored in the premises, escape, non-natural use of land, वगैरह वगैरह. So with this point settled for now, let's straight away come to the questions. In which of the following cases the court is most likely to apply the principle of strict liability? Now we are asking application based question. A fire from kitchen in a house, escape, ये natural है use of land, natural use, यहाँ नहीं होगा. A pet dog, pet लिखा है ना, natural use of land. A labor gets injured by a shaft exploding in the factory, no escape. A cattle die consuming leaves of poisonous tree out coming from neighbors. ये बाहर जा रहा था, overreach कर रहा था. 26 is Delhi. Vidhi has two cattle that can be aggressive if provoked. Which of the following situations the cattle can be said to escape as per the passage? Question number 27. Vidhi takes her along. Along मतलब वहां passage में देखो आप. I'll show you the passage. The escape within the reach of defendant after its escape. So this was the area which should have been clear in your mind. So when you talk about this along, तो फिर ये नहीं हुआ escape. Releases in the backyard, उसी के घर में नहीं हुआ. Vidhi left the cattle free for grazing outside, अब हो गया. 27 का आंसर है C. ऑल ऑफ द अबव मार्क किया है कई बच्चों ने, गलत हो गए आप लोग, आपने पार्टी नहीं पढ़ा। इसीलिए मैं बोल रहा हूं, these all questions are twisters, they are rectifying your errors, and the errors are that you don't read passage and you tend to go to the questions and you commit errors. You read passage, in the light of the passage answer question, don't answer the question based on your prior knowledge. At times what is given in passage is different from what you already know, so understand and mind well. All right, let's go ahead. Question number 28. In the above situation, if the cattles escape, which of the following elements would be immaterial, means not relevant, while holding Vidhi liable under strict liability? ऐसा कौन सा इसमें एलिमेंट होगा जो इमटेरियल होगा? इंटेंशनली, हाँ इंटेंशन इरेलेवेंट होगा. कैटल्स वर विद इन कंट्रोल और नॉट, ये रेलेवेंट है, मटीरियल है. एस्केप रेलेवेंट है. आंसर ए आगरा. अथर 28 का डी इज बैड यार. सौम्य 28 का डी नहीं. यू आर इन हैबिट ऑफ मार्किंग ऑल द अबव ऑफ दिस. दैट्स नॉट द वे क्वेश्चंस आर फ्रेम्ड ऑलवेज. Let's go to question number 29. Vidhan has a beautiful garden in his house. One fine day, heavy rain, snake comes out of the hole and escapes and bites the neighbor, and the neighbor dies. Will it be a case of strict liability? Question number 29. फटाफट आंसर बता दो. In his premise. Simple as that. सांप को विधान थोड़ी ना लेके आया था. It was not a dangerous thing. अगर उसके घर का उसका अपना सांप होता, वो सपेरा होता, in that case it would have been, a case of strict liability. Let's go to question number 3030. Possession of which of the following can be stated as a natural use of land? Storing firecracker for while evaluating. जो natural और non-natural use of land के बारे में दिया था उस पे क्वेश्चन है. Storing firecrackers in your backyard. Keeping a wild goose in the bed. ये भी non-natural. No. Wild. Devices that produce inburial. A lot of student marking. This is also non-natural. A live electricity wire which is insulated. सबके घर में होता है, ये natural use है. C. Calcutta is the answer. The answer. Question number 3131. Which of the following is not an essential condition to maintain a suit under strict liability? The dangerous thing must have escaped. Yes. 31 में बिल्कुल सही. The dangerous thing must have escaped due to defendant's negligence. जरूरी नहीं है. Anyways, they have. The defendant must have brought dangerous thing to the premises. ये है. The possession of the escaped thing must have been constituted for non-natural. Only Bombay. 31 का आंसर only Bombay. Great going everybody. So let's go to passage 7. Misrepresentation. अब एक बात याद रखना, I'm having my neck out and saying so, and I should be accountable for what I say. Any student who's not prepared well with law of contract is going to pay heavily in all the law entrance exams that they're going to take. I repeat, if your fundamentals about law of contract are not strong, you're going to pay heavy price. Make sure that you have crystal clarity about the topics of law of contract. And I mean it. This question is about misrepresentation and fraud. Where consent is not free. Free consent में पढ़ते ना. If the consent is obtained by coercion, if the consent is obtained by undue influence, if the consent is obtained by fraud or misrepresentation, in such case it is voidable at the instance of the party whose consent was wrongfully obtained. So this fundamental should be crystal clear in your mind, where when we talk about misrepresentation, तो crux में बोलूं, because you people already understand this concept well and the passage was very clear. Intentionally, if you are misrepresenting, that is fraud. And if it is innocently not revealing the right fact because you yourself are not knowing it, then it is misrepresentation. अब यहां पे warranted unwarranted information, ये warranted statement, ये unwarranted statement, ये बहुत इंपॉर्टेंट हो जाता है. आपको पता है तो ये वाले केस में भी दिया हुआ था. I think this topic is well known. Let's break into questions. Question number 32. Vidhi went to a grocery store to purchase pack of biscuits. Statement ascertaining which of the following attributes the biscuit pack will not lead to misrepresentation if found false. बिस्किट पैक पे क्या लिखा होगा? विच विल नॉट लीड टू मिसरिप्रेजेंटेशन. ऐसा कौन सा स्टेटमेंट है नीचे इसमें गलत भी होगा तो भी वो मिसरिप्रेजेंटेशन नहीं होगा? दैट्स द क्वेश्चन. विच ऑफ द फॉलोइंग डिटेल्स इवन इफ इट इज रॉन्गली रिटन इट विल नॉट अमाउंट टू. ऑल राइट. Okay. When you're talking about question number 32, students are marking A, C and D. 32 में A भी है, C भी है, D भी है. इसको देख लेते हैं बेटा. डेट ऑफ मैन्युफैक्चरिंग. डेट ऑफ मैन्युफैक्चरिंग अगर किसी प्रोडक्ट की गलत लिखी हुई है तो ये मिसरिप्रेजेंटेशन है, बिल्कुल है. आप दैट इज मटीरियल, उस क्वेश्चन में लिखा था मटीरियल इंफॉर्मेशन. मटीरियल इंफॉर्मेशन है, इस पे आपको खरीदना है नहीं खरीदना डिपेंड करता है. फ्लेवर ऑफ बिस्किट, अगर फ्लेवर लिखा है आपका ओरियो चॉकलेट और आपको मिला ऑरेंज तो मिसरिप्रेजेंटेशन है. लाइकेबिलिटी, अब लाइकेबिलिटी बड़ा सब्जेक्टिव विषय है. I might like chocolate, you might like strawberry. What's the difference? How can I say everybody likes chocolate? So likability is a subjective matter. It's a subjective issue. Even if they say it is wrong, it is even if say it finds false, still it will not be misrepresentation. ये दोनों अगर false हुए तो misrepresentation हो जाएगा. Answer is going to be C, Calcutta. People marking C, great going. People marking A and D, you miss the bus. All right. 32 का डी कभी सही नहीं हो सकता. आप समझो, पैराग्राफ में लिखा है, पैसेज में लिखा है वैल्यू और क्वांटिटी ऑफ द सब्जेक्ट मैटर टू अग्रीमेंट. ठीक है, आई होप यू गॉट इट. चलो आगे चलते हैं. क्वेश्चन नंबर 33. In the above situation, Vidhi asked the shopkeeper for salted biscuit and he gave sweet biscuits. So what would be your answer? Will it be misrepresentation or not? Question number 33. Jayesh, Vidhi, Priyashi, Deepika, Muskan, Arora and Rachit, Kaushiki, Anurag. They all have been answering. Barring Anurag, everyone is right and Anurag has smartly deleted the message as well. I don't know. गलत थे तो गलत थे ना, क्या फर्क पड़ना है? Whom to show and why to show and why worried? इस केस में शॉपकीपर को मालूम था कि वो सॉल्टेड नहीं है एंड उसने इंटेंशनली एक मिस इन्फॉर्मेशन देके सॉल्टेड बोल के स्वीट दिया. सो दिस अमाउंट्स टू फ्रॉड. इंटेंशनल है क्योंकि इसलिए. Question number 34 on your screen. While entering into a contract of sale, Vidhi, the buyer, asked Vidhan if the property was registered. In order to sell the property, Vidhan, aware of the true fact, said that it is registered. Which of the following arguments? इनमें से कौन सा argument अगर सही होगा तो विधान को बचा लेगा? Which of the following arguments, if true, would help Vidhan escape liability under misrepresentation? Question number 34. चलो ठीक है. अब इस केस में विधान विल नॉट हैव एनी इनविल टू इट्स. नो. विधान डिड नॉट हैव एनी ड्यूटी. ही हैड. विधान हैड चेक्ड रजिस्ट्री एंड मेड श्योर द प्रॉपर्टी वाज रजिस्टर्ड. यही एक आर्ग्यूमेंट है कि विधान बोले कि मैंने रजिस्ट्री देखी थी और रजिस्ट्री हुई थी. If this is what he'll be able to say, he'll be escaping the liability of misrepresentation, otherwise not. C, Calcutta is the answer. Runit Singh, D. इज ओनली एजेंट, ये कहां लिखा है रुनित? बैड वन। तनु रॉन्ग। ध्वनित गलत। तनिष सिंघानिया बेटा गलत। अनुराग परिहार, अविरल, संस्कार एब्सोल्युटली रॉन्ग। क्वेश्चन समझ में आया? विधान एक प्रॉपर्टी बेच रहा है, उससे पूछा खरीदने वाले ने क्या ये रजिस्टर्ड थी, उसे मालूम नहीं था, उसने बोला है। अब कौन सा ऐसा आर्ग्यूमेंट होगा जो विधान को बचा सकता है मिसरिप्रेजेंटेशन से? यही आर्ग्यूमेंट बचा सकता है कि उसने रजिस्ट्री देखी थी और उसने इंश्योर किया कि प्रॉपर्टी रजिस्टर्ड थी बिफोर आंसरिंग विधि। अगर ये सही है तो उसकी लाइबिलिटी नहीं है मिसरिप्रेजेंटेशन में। आंसर है सी कैलकाटा। लाइक्ड इट? सो कीप लाइकिंग। ये क्वेश्चंस आर इंटरेस्टिंग where you have put that this argument will go in favor of x or y or वगैरह वगैरह. This is interesting. Question number 35. Vidhan read on Facebook that papaya leaves cure jaundice. कहां पढ़ा उसने? फेसबुक। कम शब्दों में बोलूं तो अनवारंटेड इंफॉर्मेशन, जो हमारे पैसेज में लिखा था ना, and I marked it as well initially. When we see question number 35, C Calcutta, answer is done. All right. Good. All of you marking C, so not explaining more. Next is a car owner while selling car as second hand to the mechanic hides the fact that the car met with an accident in past. अब ये पढ़ते से ही आपको क्या लगता है? अब आपको पढ़ते से ही लगता है क्वेश्चन नंबर 30 में से जानबूझ के नहीं बताया। Runit, read well the passage. You missed the bus. You missed the bus. Read the passage very carefully. What is he doing in question number 35, 34? Read well. Sell property. He derived no benefit. Come on. He's selling a property. Now, which of the following read this question number 36. Intentionally. And since it is intentionally, answer is going to be 36 ka A. Those who are marking C, none, as the owner was silent about the fact of accident. Please understand, he hides that his car met with an accident in the past. What is he doing? He is concealing a material information. What would it amount to? Fraud. A. Agra. Correct, Vedic. Let's go ahead. Let's look into the ultimate. We were on a penultimate passage. Now it's the last passage of the day. The death penalty. When you talk about the death penalty, then what is in the question is about a Law Commission of India's report, then Rajendra Prasad's case, then Bachchan Singh and all Machi Singh case, which is talking about the doctrine of rarest of rare. Then the Nirbhaya's case, they're saying that asking for forgiveness and the mother of Nirbhaya shall forgive the person who is accused in the case of brutal case of Nirbhaya is a futile argument. That is what author is trying to put up. And he says that death sentence can be given in offenses, and these are offenses which are herein mentioned. लॉ कमीशन का व्यू बताया, जजमेंट्स बताया, निर्भया केस का एग्जाम्पल लिया, इंडियन पीनल कोड में ऐसे कौन से ऑफेंसेस हैं जहां पे डेथ पेनल्टी दी जा सकती है उसको मेंशन किया। यही था ये पैसेज, इस पे 4 क्वेश्चंस थे। लेट्स गो टू द क्वेश्चंस। क्वेश्चन नंबर 37, बी क्विका। गो टू क्वेश्चन नंबर 37। Quicker you are, the better it goes. Whenever you get tricked, you need to answer. Question number 37. Rachit, Jayesh, Anurag, Kaushiki, Laksh, Muskan, Mahima, they are right. Deepika is wrong. Vedic is right. Please understand. Raping a 7-year-old girl, it is rarest of rare. Death penalty can be awarded. Why? Out of two, it is majority opinion. और majority opinion का लिखा हुआ है आपके passage में भी. So people marking B, they're absolutely wrong. Many marked B. Answer to this question number 37 is C, Calcutta. Let's go to question number 38. Based on the information given in the passage, what can be inferred about the status of death penalty in India? क्या inference draw कर सकते हैं? Question number 38. Waiting for your answers. I'm waiting for your answers because there are some twisters in the questions. If you're able to figure them out, good, it's good. Otherwise, you miss the bus. And this is where you should have your learnings. Now, this is how it is. A and D. Now A is increasing. D is also increasing. Let's see question number 38. A is in majority. Conviction by death penalty is only possible in rarest of rare cases. Absolutely right. But till here, as defined in constitution, nahi, as provided judgment se aaya hai, this part is wrong. Conviction by death penalty is only possible in the case of treason. No, wrong. Or bhi offenses hain. In India, the death penalty can be only inflicted in lethal by lethal injections. Now, when you talk about 38, no, it was proposed. For crimes of treason and murder, the initial line of the passage, D, Delhi is the answer. You missed the bus. You were tempted to mark A, but the answer comes out to be D. If you missed it, do like it. You should have more learning. वो फटाफट दिखते ना वहाँ पे like so get to understand कि हाँ गलती हुई है दिख जाता है. Penultimate question of the day. Question number 39. Vidhan was accused of murder. The court awarded death penalty. He applied to the higher court but upheld. The same was upheld. Vidhan then files a petition to the president requesting him for वगैरह वगैरह. पूरी कहानी दी हुई है उसकी. Question number 39. Question number 39. Oh my god. Question number 39 is the penultimate question of the day. Everybody is right. Answer is this. Of course, yes. D. Delhi is correct. Nature of crime should be considered. Now is the last question. Even the question can be asked in this format. Statement 1, statement 2, and which is correct. The last question is, death penalty is to be awarded in rarest of rare case as determined by Constitution of India. Now, when you talk about question number 40, तो ये कॉन्स्टिट्यूशन के कारण गलत हो गया. डेथ पेनल्टी विल बी अवॉर्डेड फॉर मर्डर ट्रीसन वगैरह वगैरह द सरकार. ये सही है. स्टेटमेंट 1 इज इनकरेक्ट. सही है. स्टेटमेंट 2 इज इनकरेक्ट. गलत है. तो ये दोनों अपने आप गलत हो गए. ये आगरा इज द आंसर. एफेबल सोल. सर विल देयर बी 10 सवाल दिस ईयर? बेटा हुआ यू आई मीन आर यू अपेयरिंग फॉर आई मीन यू लास्ट ईयर लिया था मैंने 10 सवाल के बहुत सारे सेशंस. डिड इट बेनिफिट यू? फायदा हुआ उसका? चलो व्हाटएवर. आज तो 40 सवाल हो गए बेटा. आप 10 सवाल बोल रहे हैं. चलिए. So that's all precisely from my end. When we go ahead, we get to understand one thing very clearly. Today, the topic was really brain churning, and I believe a lot of students might have got a bit upset with their scores. But what matters is that the kind of learning that you take from your mocks, they help you more. To everybody at home, I कॉन्फिडेंस 0 to 5% पे आ गया तो वापस ले आओ बेटा. गिरते हैं सहसवार मैदाने जंग में, वो तिफल क्या गिरेंगे जो चलते हैं घुटनों के बल। कहीं पढ़ा था मैंने, ये बड़ा एप्ट आपके लिए है, तो आप समझ लीजिएगा। दूसरी बात, ये एटीट्यूड होना चाहिए। आज के मॉक में अगर सही कई सारे क्वेश्चंस आपके गलत हो गए तो you should improvise on your score and should get better. To a child affable soul who is saying yes sir for 10 sawal, I'll if you can, if you wish to, write an email to me at bahul@vidhigya.in. So if at all I could help you, otherwise I'll do the possible help. All right. The personal ID, the child, if you could be helped at this juncture, I'll be more than happy helping you. So that's all from my end, है ना? और ये जितने भी टेस्ट हो रहे हैं, आप याद रखिएगा, जो मॉक में टॉप करता है जरूरी नहीं एग्जाम में टॉप करे। आपके लिए जरूरी ये है कि आपके जब भी जितने भी सेक्शंस अच्छे से हो गए, उन्हें पढ़ें, समझें और बेहतर करते जाएं। सो दैट्स ऑल फ्रॉम माय एंड, है ना? स्टे हैप्पी, स्टे एनर्जेटिक एंड स्टे लॉजिकल। स्टे लॉजिकल विद विधिज्ञ, योर बेस्ट पैल इन क्लैट प्रेप्स। याद रखना, जीतना तो हमें ही है। ऑल द बेस्ट एवरीवन, गुड नाइट, टेक केयर।